Good day, Crime Talk aficionados. A lot of chaos in courtrooms today. First, Karen Reed's attorneys ask for a mistrial. Lori Vallow shows up in a wheelchair. The Diddy trial erupts in chaos. What should happen to somebody who frames somebody for a crime? An escapee takes to social media to plead for his case and goes straight to the president. Parents charged for letting their 7-year-old walk to the grocery store and he dies. Update on the overpass rock throwing case. A man with bad thoughts does terrible things with a knife. This day in legal history, our quote of the day involves expert witnesses and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And yes, check us out anytime on any of your favorite podcasting apps. Now, before we get to all the chaos in the courtroom today, let me remind you to go to crimetalksearch.com where you can sign up for that background subscription service. When you do, you'll be able to do many background searches on anyone here in the United States as your heart desires. And you do the search. It is literally prepared while you wait, and the report is emailed to you. And you can even ask for updates if information changes. You're going to get in that report information regarding cell phones associated with the person you're searching, social media presence, email addresses, as well as criminal history. Are there liens, judgments? Do they own property? Are they on a sex offender registry? And most importantly, do they have a criminal history? That's right. If you're maybe going to date somebody and you have small children, you probably don't want to be dating the guy that has charges with dealing with inappropriate things with children. Hey, it could get you charged if you do. So go to crimetalksearch.com, sign up for that background subscription service today. You're going to be very happy that you did. All right, ladies and gentlemen, let's go ahead and get to the docket today. So let's open the record for June 3rd, 2025. And first on the docket, Karen Reed's attorneys move for a mistrial. So remember from the first trial, the German Shepherd, Chloe? Well, she's kind of taking center stage in Karen Reed's second murder trial today as it relates to the woman accused of killing her then Boston police officer boyfriend, John O'Keefe. Now, the German Shepherd named Chloe has emerged as a pivotal element in the defense case in chief, and the trial is now in its 7th week as of June 3rd, and obviously people are watching it. Some people a little more intently than others. Apparently, our audience isn't huge on the Karen Reed, but you go to X or something, this is the only thing people are talking about. And I think the defense case has turned into a complete catastrophe, crashing and burning before our very eyes. But I digress, so let's continue. For those who don't know, John O'Keefe's body was found in the snow outside a Canton, Massachusetts home back in January of 2022 during a apparently historic blizzard. Now, prosecutors allege that Reed struck O'Keefe with her SUV at approximately 25 miles per hour, causing a fatal head injury and left him to die in the cold and snow. Reed's defense team, however, counters that she was framed, claiming that O'Keefe was beaten by fellow police officers, then allowed to be attacked by a dog, and then abandoned outside the front house where the beating and dog attack apparently took place. The defense further alleges that the now former Massachusetts State Trooper Michael Proctor, the lead investigator on the case at the time, orchestrated a cover-up. Anyway, like I said, a lot of public interest, particularly after the hung jury in Reed's first trial back in 2024. And like I said, I would have found her not guilty because the prosecution did such a horrible job on the first trial. But this trial, prosecution, they're winning. If, trial's like a tennis match, it's like 40-love at this point, in my humble opinion. Anyway, Chloe's role in the defense, remember the German Shepherd? That was the dog residing at the house where O'Keefe's body was discovered. Anyway, the defense put on Dr. Maria Russell, a physician and forensic specialist, and she testified that a large superficial gashes on O'Keefe's arm were consistent with canine claws and teeth. She returned to the stand on day 2 today, where Russell reiterated her findings, describing the wounds as characteristics of incomplete dog bites that did not fully penetrate the skin. Now, Russell's testimony challenges the prosecution narrative, contrasting that their crash reconstruction expert Judson Welcher, who suggested that O'Keefe's injuries resemble those from a vehicular impact, the car. Anyway, Russell disputes this, noting that O'Keefe's wounds lack the skin loss typical of such a collision. Now, the prosecutor's cross-examination by Special Prosecutor Hank Brennan rigorously questions Russell's conclusions, and he highlighted the absence of dog DNA on O'Keefe's sweatshirt, which tested positive for pig DNA of unknown origin. Anyway, Russell acknowledged that the dogs typically leave saliva and hair when biting, but noted that the sweatshirt was not tested for DNA until months after O'Keefe's death. She argued that immediate swabbing would have been ideal for a thorough investigation, a point that Brennan countered by stating that no evidence initially suggested that there was a dog attack. Anyway, Brennan also questioned Russell's methodology, noting the lack of standardized approach for identifying dog bites. Russell explained that she relied on pattern recognition and differential diagnosis, acknowledging challenges in distinguishing between tooth and nail marks due to their similar abrasion patterns. When pressed about variations in the spacing of O'Keefe's wounds, she attributed them to skin elasticity. Additionally, Mr. Brennan raised concerns about Russell's communications with the defense. He referenced a December 2024 transcript where Russell admitted that the defense attorney, Robert Alessi, assisted with reorganizing her report, and Russell clarified that Alessi's input was structural and did not alter her findings. Brennan suggested that a conversation with Alessi on June 3rd during a ride to court that morning violated the witness's sequestration rules, aiming to undermine Russell's credibility. Now, this became yesterday where this witness was completely floundering on the stand. And today she's like, well, I'd like to see a transcript of it. And Brennan wisely said, well, why are you asking to see a transcript of it? Did you have a conversation about something like that? Well, yeah, I mean, I may have been driving to court today with the attorney, and he may have suggested that I take a look at a transcript before I agree to anything. Oh, really? You were discussing your testimony, even though you haven't finished your testimony? Yeah, that could potentially be a violation of the sequestration order now, couldn't it? Anyway, the defense moved for a mistrial after Brennan questioned Russell about dog DNA testing, arguing that it was improperly introduced DNA evidence, and the judge denied the motion and allowed the prosecution to continue its line of questioning. Now, the defense had maintained that they had deliberately avoided mentioning DNA, while Brennan noted that the defense had raised the concept at hearings as far back as December of 2024. Now, when the defense got up and said they strenuously are going to object to this questioning and they want a mistrial and the prosecution has done wrong, I literally rolled my eyes and said, you've got to be kidding me. This is your expert witness that you put on the stand to say that this was dog bites evidence, right? And you asked the witness to say, was there anything that would suggest that this was from a vehicle impact? Really? Have you been watching the first 25 days of this trial? Anyway, the defense wanted to avoid the DNA because it looks bad for the defense, right? They're advocates. They only want to bring up what is good fact. But when you put an expert opinion out there, and you have an expert opine as to that opinion, you get to test the basis of that opinion. Okay, doctor, just like Brennan did. Okay, doctor, you say that this was not a cause of an accident with a car. Well, did you consider this? Did you consider the car, the height, the weight? Did you do any testing? Did you go look at anything? No. That goes to the weight of their opinion, ladies and gentlemen. The judge, I'm not a big fan of, but the bottom line is she made the correct decision. If you make an opinion, if you're allowed to testify to an opinion, whether an expert or a layperson, guess what? You get to have the basis of that opinion challenged. If I was on trial and I was charged with a crime of violence and I put on peacefulness evidence, right? Someone could get up and say, well, Mr. Witness who says Scott Reich is peaceful, did you know that one time where he erupted and just lost his mind and yelled at everybody and threw everything around the room? Now, I'm not a yeller or a screamer, so that'd be out of character, but they would get to test the basis of that opinion, ladies and gentlemen. So, and I'll be honest with you, I've been trying to refrain. Like I said, first trial, I would have found her not guilty. Prosecution sucked. This time, the defense sucks. All right. Every witness, and I told you this comes with the fact that you now have an experienced prosecutor and defense attorney prosecuting the case. He has anticipated everything that the defense has tried to put up, and he has decimated their case. They are floundering right now. And this Dr. Russell, she's an embarrassment. There's a reason why she's never testified as an expert anywhere. She is atrocious. She should be embarrassed for herself. The defense should be embarrassed for hiring this woman. She changes her testimony to fit whatever narrative. She volunteered, tried to input herself into this situation. Absolutely embarrassing. All right? I'm just going to leave it at that. Absolutely embarrassing. I would want to get her off the stand. Defense, when we started this, they were going back to do another redirect of her. Like, get her off the stand. She sucks. And the jury's got to be sitting there saying, where's the dog bites theory come in here? Because we heard about all this testing and all the data. Even according to Karen Reed, says all the data says, the car was struck. Her own word said that she struck him. For God's sakes, people, a little intellectual honesty here would be good. All right. Talk about bias. If you're completely ignoring this, and if you think the last couple of witnesses have been good for the defense, you're not being intellectually honest with yourself. You are not. Now, who knows? Lori Vallow? Now, who knows? Karen Reed? She could win. Maybe they pull one out of the hat here, and I'm completely wrong, and I will eat the magic 8-ball. All right? But from this attorney's perspective, it is not going well. Next on the docket, Lori Vallow shows up to court in a wheelchair. That's right. So the trial of Lori Vallow there in Maricopa County, Arizona, on the charge of conspiracy to commit the murder of her former nephew-in-law, Brandon Boudreaux, has been postponed due to the defendant's health issues. Now, according to various accounts there in the courtroom, based upon courtroom's observations, the events leading to the continuation of the trial date. Now, the court session concluded, and they're suspended until Wednesday. The judge apologized to jurors for the delay, instructing them to return to court Wednesday morning, and he advised them not to research, anything about the case because they're not supposed to do that. Anyway, the jurors responded positively, saying that'll work. Anyway, the judge expressed embarrassment. The judge notes that it's an unprecedented situation in his career where it's arising where jury selection from the proceeding was planned and basically had to stop. So he apologized for any of the inconveniences, and the jurors were ultimately led out of the courtroom. One juror was excused due to a scheduled camping trip, and Lori's advisory attorney and prosecutors left the courtroom when the judge appeared visibly frustrated between an emotional exchange between Lori Vallow. Anyway, Lori Vallow was crying loudly and refused to move from her wheelchair, apparently, and the judge requested that she and the prosecutor exit, preparing to address jurors without the attorneys present. Now, the judge suggests Lori move to a regular chair for jury selection, but she resists, citing health concerns and stating, "You are putting a lot of pressure on me to be better by Wednesday." She expressed worry about being compelled to attend if her condition persists, and the judge confirms he may order her presence on Wednesday, and proposing the next day off to, like I said, assess her medical conditions. It was unclear exactly what took place, but apparently she is suffering some sort of flu-like symptoms and just doesn't feel as though she can proceed. Hence the reason, she showed up in a wheelchair. And like I said, when the judge said, "Why don't you sit in a wheelchair?" she said she couldn't, and that she needs time to recover so that she can represent herself, and that this is completely out of her control. She's sick. Anyway, like I said, she's sick. The question now becomes whether, what's the word I'm looking for? Is she malingering, trying to delay? What is she trying to do in this particular situation? Now, if she is truly, legitimately sick, I get it. Now, fortunately, I don't get sick that often. Occasional cold or something along those lines. But for the most part, I stay pretty healthy. So I've never done a trial other than maybe with some exhaustion or something along those lines. But I certainly wouldn't be on my game if I had to do a trial and I was sick. If she's sick, I get it. You don't want to perform like that. However, the problem is they're starting voir dire. They have the jury. The judge is the one that, and Lori Vallow is the one that kept pushing this case. She's raised speedy trial issues along the way, but now she, basically can't have her cake and eat it too. So we'll see. We'll check back in on Wednesday. We're going to bring you the trial. We'll see if it starts on Wednesday. Next on the docket, the Sean Diddy trial erupts in a little bit of chaos today. For those who don't know, Sean Combs is currently on trial in a federal courtroom in New York City, facing serious charges of sex trafficking and racketeering. And if convicted of allegedly operating a criminal enterprise over 2 decades, let's face it, he's probably going to spend the rest of his life in prison. So what happened today? Eddie Garcia, the former security guard at the Intercontinental Hotel in Los Angeles, testified about an incident in 2016 where Combs was recorded assaulting his then girlfriend, Cassandra Cassie Ventura, in a hotel hallway. Now, Garcia revealed that Combs offered him $100,000 to delete the surveillance footage, which was later made public in May of 2024. Now, Garcia, who demanded immunity before testifying, recounted how Combs' associate, Christina Courtroom, and Combs himself repeatedly contacted him to secure the video. Garcia stated that Combs appeared nervous, claiming intoxication and fearing reputational damage. Garcia ultimately handed over the footage after his boss, Bill Medrano, negotiated a $50,000 deal, with Garcia receiving $30,000. And so Combs required Garcia to sign a non-disclosure agreement with a $1 million penalty for breaches. We also heard from Regina Ventura, the mother of Cassie Ventura. She testified about a 2011 incident where Combs allegedly demanded $20,000 from her, threatening to release explicit videos of Cassie and harm her and her new partner, rapper Kid Cudi, whatever his name is. Who cares? Anyway, Regina described feeling physically sick and took out a home equity loan to pay Combs, fearing for her daughter's safety. The money was returned days later, and Cassie resumed her relationship with Combs. Now, Derek Ferguson, Combs' former CFO, corroborated this account, confirming a $20,000 transaction from Regina to Combs' account, for which was subsequently refunded. Now, then we had the former assistant just the other day, Mia, testify under a pseudonym of Mia, describing her experience as Combs' assistant, including cleaning up after the infamous freak-off parties. She detailed the chaotic state of a hotel room with candle wax, broken glass, blood, and oil, which assistants were tasked with sanitizing to prevent leaks to the media. And then a supporter of Combs was escorted out of the courtroom today after breaking the courtroom decorum rules by yelling basically statements in favor of Sean Combs. So chaos everywhere today, ladies and gentlemen. Chaos everywhere. We got bad attorneys in the case for Karen Reed. We got Lori Vallow representing herself, showing up in a wheelchair, refusing to get out of the wheelchair, and people standing up yelling in the Combs trial. You got to love court. You never know what's going to happen. Never know what's going to happen. So what do you think should happen to somebody if they, try to frame somebody for a crime? Well, prosecutors in Milwaukee County have revealed that Ramon Morales Reyes, a 54-year-old immigrant from Mexico, was falsely accused of planning to assassinate Donald Trump. The accusations stem from a fabricated letter sent to an Immigration and Custom Enforcement agent, with authorities now believe was written by Demetric Scott to frame Morales Reyes and prevent him from testifying in an armed robbery case. Yes, it gets really weird. So the letter, written in English with neat handwriting, contains threats to shoot the president at a rally and claimed Morales Reyes would self-deport to Mexico afterwards. Similar letters were sent to the Milwaukee Police Chief, Jeffrey Norman, and the Wisconsin Attorney General, Josh Call, with one mentioning a bomb attack on the White House and ties to the Mexican mafia. All letters listed Morales Reyes as the sender with his return address. But investigators grew suspicious when they discovered Morales Reyes, who was arrested by ICE following the letters, doesn't speak, read, or write English in any way. He denied any involvement and suggested Scott the suspect in the September 2023 robbery, where Morales-Reyes was the victim, was responsible. Now, Morales-Reyes had identified Scott as the individual who assaulted him and stole his bicycle, and he was expected to testify against Scott in an upcoming trial. Well, on May 30th, a search of Scott's jail cell uncovered a blue pen matching the turquoise ink used in the letters, an envelope with the Milwaukee ICE office address, and a note indicating Scott sought the Attorney General's office address. Scott, already incarcerated, alleged, admittedly to writing the letter, stating he wanted to eliminate Morales-Reyes as a witness. He claimed his mother assisted in mailing the letters, but was unaware of their contents. Well, Scott now faces additional charges of witness intimidation and identity theft, with a court appearance scheduled for today. Now, Morales-Reyes, found to be illegally in the United States, has a criminal record, including a felony hit and run, criminal damage to property, and disorderly conduct. He is currently detained at the Dodge County Jail there in Wisconsin, pending deportation proceedings. And when Morales-Reyes was arrested, the Department of Homeland Security, Kristi Noem, praised the action, attributing the threat to rhetoric against the president. However, the subsequent investigation shifted focus to Scott's alleged manipulation, exploitation, anti-immigrant sentiment to target Mr. Morales-Reyes. I say throw the book at him. Now, obviously, Mr. Morales-Reyes has got his own problems, but he didn't need any more problems that weren't his, so to speak. And if you're going to write a letter like that, well, when they find out, be prepared to accept the consequences. Next, an escapee takes to social media to proclaim his innocence. That's right. The United States Marshal Service is investigating a video posted on Instagram by a man claiming to be Antone Massey, a 32-year-old fugitive and one of the 2 inmates still at large following the jailbreak involving 10 inmates in New Orleans last month. The video, first posted on Sunday and later reposted by another account with the same username on Monday, has been deleted. In the video, the man, whose distinctive facial tattoos match those of Massey, claims he was let out rather than having broken out of the jail. He alleges he fled due to fears of receiving a life sentence for crimes he claims he did not commit. And Massey was detained in March on charges of motor vehicle theft, domestic abuse, battery involving strangulation. He's also wanted in St. Tammany Parish on suspicion of kidnapping and. Now, the man in the video appeals to President Donald Trump and others, requesting a federal investigation into alleged corruption within the Louisiana justice system. And the Deputy U.S. Marshal Brian Fair and another law enforcement sources confirmed to the press that the video is under investigation and appears to feature the missing fugitive. Now, Massey has a history of escapes, with this incident marking his 5th, including 2 prior instances of removing ankle monitors. One of the 10 escapees, 8 have been recaptured. The only other fugitive still at large is Derek Groves, a convicted double murderer incarcerated since October. You know, you got to love people that want to fight their case on the outside. I get that. But you have to post bond legally. You can't just escape from the jail and then claim, I was forced to leave because of duress. The system is so corrupt, I had to escape to let you know how unjust this system is. Next, more parents charged for the actions of their kids, I guess. I don't know. Parents who let their 7-year-old walk to the grocery store, charged with murder. So today, 7-year-old Legend Jenkins was fatally struck by a Jeep driven by a 76-year-old woman in Gastonia, North Carolina, while walking home from a grocery store with his 10-year-old brother. Now, the Gastonia Police Department stated that Legend ran into traffic and the children were unsupervised at the time of the incident, and the driver will not face charges as police found no evidence of speeding or wrongdoing. Now, Legend's parents, Jessica Ivy and Samuel Jenkins, were arrested last Thursday and charged with involuntary manslaughter and child neglect, both felonies. Prosecutors allege that the parents are guilty of these charges. Obviously, they've entered a plea of not guilty, and the parents have actually been denied permission to attend their son's funeral, as their bond is currently set at $1.5 million. Now, I don't know what the first time was when I got to walk to the store by myself, probably thought it was a really big kid. Maybe my brother went with me. I don't recall. And if I had jumped into traffic, I certainly wouldn't want my parents to be charged. But I don't know. 7, is that too young? I don't know. It depends on maybe the streets, how busy the intersection is. I don't know. Hey, the kid is 10, right? You can technically charge the kid. Why not charge his brother too? Throw it all in there. That's an absolute tragedy. Unless the parents were at home doing drugs or intoxicated, I'm not sure that's a case that necessarily needs to be prosecuted. But hey, let me know if you think I'm wrong. All right, let me give you an update on that rock throwing from an overpass. So today, Joseph Koenig was sentenced to life in prison without the possibility of parole, plus an additional 60 years to be served consecutively for the murder of Alexa Bartel. Now, Koenig was convicted of 19 charges, including first-degree murder, attempted murder, third-degree assault, and attempted third-degree assault stemming from an incident back in April 19th of 2023. Now, Bartel, a 20-year-old woman, was killed when a large landscaping rock was thrown off the overpass by Koenig, crashing through the victim's windshield as she was driving. Now, Koenig was arrested approximately 1 week after Bartel's death, alongside co-defendants Zachary Quack and Nicholas Carroll Chick. Now, both Quack and Carroll Chick accepted plea deals, agreeing to testify against Koenig. And during the trial, Quack testified that the group collected landscaping rocks from a median, and that Koenig and Carroll Chick threw rocks at stationary vehicles. Now, Quack describes Koenig throwing a rock as a shot put style with his dominant left hand. Carroll Chick testified that Koenig threw the rocks that killed Bartel. Now, the sentencing included some emotional testimony from Bartel's family and survivors of the similar attacks. Jenna Griggs, Bartel's girlfriend, recounted finding Bartel after their phone call abruptly ended. Kelly Bartel's Alexa's mother described an instinctive urge to give her daughter an extra hug before her death. Other witnesses included Eleanor Davis, Nathan Tipton, and Brian Smith. They testified about rocks shattering their windshields while driving. At sentencing, Bartel's parents delivered an impact statement expressing profound grief and describing Koenig's actions as stealing their daughter's future. Koenig apologized, acknowledging his responsibility for Bartel's death. So there went his appeal right there. Anyway, Quack was sentenced to 32 years in prison, and Carroll Chick received 45 years when they were sentenced back in May. Now, the judge in sentencing Koenig emphasized his actions demonstrated a disregard for human life, and the jury deliberated for over 7 hours before ultimately delivering a guilty verdict. What happens when you had bad thoughts about stabbing somebody? Sometimes you go stab somebody. So a 17-year-old man by the name of Dylan Lentz faces charges of first-degree attempted intentional homicide following the attack on a 17-year-old girl in Beaver Dam, Wisconsin. This all took place last Saturday evening. Now, according to the criminal complaint, Lentz provided a detailed account to a Beaver Dam Police Department detective describing how he stabbed the victim with a box cutter and subsequently struck her multiple times with his vehicle, a Pontiac Vibe, in the parking lot of a Walmart about 9 p.m. The complaint states that Lenz admitted to premeditating the attack, quoting him as saying, quote, "While I'm in the store, I was like, this is the last day she was going to be alive. This was the last night of her life," end quote. He further described losing control during the incident, stating, "My body just took over." Lenz allegedly stabbed the victim and, after a struggle over the box cutters, allowed her to flee when she pled to leave. However, he later pursued her with his vehicle, admitting to the detective that he intended to kill her to prevent her from reporting the assault to the police. Now, a witness reported seeing the Pontiac Vibe making erratic movements and striking the victim repeatedly, obviously prompting the person to call the police. The victim sustained severe injuries, including a spinal injury requiring surgery, paralysis below the waist, broken ankles, road rash from shoulders to feet, and shoulder injuries. She was initially treated at the Marshfield Medical Center before being airlifted to the University of Wisconsin Children's Hospital. Investigators identified Lentz's vehicle through Walmart surveillance footage, which provided the license plate number. And at Lentz's residence, officers observed blood on the car's exterior, grass lodged in its frame, and a broken license plate frame matching debris from the scene. Lentz's mother claimed blood in the back seat belonged to her son and was caused by the victim, but Lenz's statement to the detectives contradicted this, detailing his use of the box cutter and his violence intentions. He also admitted to having recurring bad thoughts prior to the attack. Anyway, Mr. Lenz appeared in court. He's got a $150,000 cash bond, and the matter will be set for a preliminary hearing. The charges carry a maximum of 60 years in prison, and Mr. Lenz acknowledged the severity of his actions, texting a friend afterwards saying, "I really messed up, and this time I did something really, really bad." Mr. Lenz, that is not an attack with your car. You can completely disregard the damage to your car. Obviously, this was part of a conspiracy by Walmart. And then she was probably attacked by a dog, which resulted in the paralysis. Just giving you the heads up on the defense. Now, for those who all took that seriously, that was total sarcasm, ladies and gentlemen, because some people can't tell the truth. Next, this day in legal history, on June 3rd, 1873, the Department of Justice was investigating bank fraud tied to the Panic of 1873, leading to the convictions and reform in the financial crimes law, including banking regulations. On this date in 1883, federal agents were arresting Chinese immigrants under the Chinese Exclusion Act of 1882, sparking legal challenges over immigration and citizenship rights. Have you noticed, ladies and gentlemen, the more things change, the more they stay the same? On this date, June 3rd, 1893, a mob of 1,500 white people lynched black man Sam Bush on the courthouse lawn in Decatur, Illinois. The lack of legal consequences fueled demands for federal anti-lynching laws. And on this date, June 3rd, 1914, federal prosecutors were pursuing the Mann Act cases, targeting interstate prostitution and human trafficking, expanding federal jurisdiction. Once again, ladies and gentlemen, have you noticed it's all the same stuff? You can go back, go into a law library, pull any book, any law book off the shelf from the early 1900s. It's the same stuff, ladies and gentlemen. Same laws. The more things change, the more they stay the same. It's all about sex, drugs, alcohol, and violent crime, ladies and gentlemen. There you go. And then every 50 years, we try to reform something, saying, look how enlightened we've become. And then everybody overextends, like most things they do. The pendulum swings too far, and then it swings back too far the other way. Just something to think about. Anyway, on June 3rd, 2013, U.S. Army Private Chelsea Manning trial begins at Fort Meade, Maryland, for leaking classified materials to WikiLeaks. Her convictions under the Espionage Acts raised debate over the whistleblower protection and national security laws. And of course, I don't think she was Chelsea yet. At that point, I think that was while she was in prison for that. And of course, she did get a reduction in the sentence, not a pardon, but a commuted sentence as well. Next, our quote of the day, since we're talking about terrible experts in the Reed case. Remember, an expert witness does not testify to facts, but to opinions based upon specialized knowledge, offering a court a lens through which complex evidence can be understood with clarity and precision. So ask yourself, did Dr. Russell present evidence with clarity and precision? No, I saw a bumbling, retired physician, very smart, very well educated. I get it. But I think she wanted to interject herself into the case and maybe get a little more business so she can be an expert in her retirement days. I don't think she's going to get too many more of those. Next, our dumb criminal of the day, ladies and gentlemen. The Float Bandit's Folly. That's right. In the sleepy, sun-drenched suburb of Palm Bay, Florida, where backyard pools sparkle like sapphires, a rogue named Christopher Monin waged a most peculiar crime spree. The 41-year-old wasn't after jewels or cash, but something far more buoyant. That's right, pool floats. The inflatable darlings of summer, which he coveted for, shall we say, deeply personal reasons? Well, the jig was up one muggy night at 1:30 a.m. when a sharp-eyed Palm Bay cop spotted Monin weaving through the streets on a bicycle, a bulging garbage bag slung over his handlebars. A quick peek revealed the haul, a deflated flotilla of pool floats, lobsters, turtles, even a cheeky strip of bacon, all swiped from the porches of dozens of neighbors. For months, Palm Bay had been besieged by such thefts, which slashed screens and missing floats, leaving residents baffled. Anyway, Monin, it turned out, was the phantom of the inflatable heist, and under questioning, Monin folded like a cheap air mattress, confessing to raiding countless lanais and amassing many floats. He even played tour guide, leading cops to a vacant house across from his own, where his treasure trove awaited. Inside, officers found a staggering 75 floats, a psychedelic armada of pizza slices, watermelons, and Shaquille O'Neal branded lounger that screamed slam dunk. Now, Monin, poolless himself, admitted to using the floats for private escapades, insisting it kept darker urges at bay. Well, the case bobbed through the court system for years, finally washing ashore just before Monin's June 2nd trial. Staring down hefty burglary and theft charges, he struck a plea deal citing a mental condition distinct from addiction, and that demanded specialized care. The judge, perhaps tickled by the sheer oddity, sentenced him to 2 years of community control, a probation so tight it's practically a leash, followed by 8 years of standard supervision, a crisp $840 fine, 80 months already served in the county slammer sealed the deal. Now, Monin's rap sheet is no stranger to inflatables. Since 2007, he's racked up convictions for float-fueled burglaries, thefts, and even a 2017 loitering bust with a raft tucked in the bike basket. Each caper bore the same quirky hallmark, as if the floats were his siren song. Now, as Palm Bay's pools gleam under the moon, Monin drifts under the weight of probation. His float-snatching days hopefully popped. The neighborhood floats on ducks and French fries, bobbing safely once more, spared the affection of the man who loved them so dearly. That's all we have for today, ladies and gentlemen. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.